So we need to talk about a case which was recently granted Supreme Court review. This case attempts to build off of a prior 9-0 unanimous decision by the Supreme Court, which impacted our rights to prevent the unlawful search and seizure of firearms within our home without a warrant. So let's break down what just happened. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is to simply like, comment, and subscribe. All those things help to grow the channel, of course, and just drop a positive comment down below because that tells the algorithm that you appreciate this type of 2A content and it should share it to more people. As I mentioned in the intro, in this video, we're going to be discussing a new Supreme Court case which was granted review, and it involves when police can enter someone's home without a warrant under certain exceptions. This case tries to use a prior 9-0 unanimous decision by the Supreme Court, which involved the warrantless search and seizure of firearms within a home. This new challenge pending in front of the Supreme Court, which was granted review, is the case called Case versus Montana. This new lawsuit should be on everyone's minds and radar because it involves when law enforcement can use legal workarounds not only to enter your home without a warrant, but also potentially confiscate your firearms without a warrant. This new case is trying to use and expand upon a prior decision which was issued by the Supreme Court called Caniglia versus Strom. In Caniglia, the Supreme Court found that the community caretaking exception to the Fourth Amendment's warrant requirement does not extend beyond into the home, it does not extend beyond vehicles, and does not apply to the home. Justice Thomas authored that 9-0 unanimous opinion, holding that police officers' seizure of Mr. Caniglia's guns within his home did violate the Fourth Amendment and was against his right against warrantless searches and seizures. This challenge, Case versus Montana, attempts to expand upon that prior ruling, and the Supreme Court has granted review to this case, and they will review and decide this case next term. Now, the facts around this challenge are not the best, but we have seen the Supreme Court grant cases like this one in the past and still issue, pretty good decisions. This lawsuit results out of an individual, Mr. Trevor Case, and his ex-girlfriend, who called police on him saying that, he was threatening to harm himself and that maybe he had a firearm. Police officers responded to that call and eventually entered his home without a warrant about 40 minutes after they arrived to his residence. They did not suspect that Mr. Case was trying to attempt to do anything, to anyone else, but potentially he maybe wanted to have an interaction with police officers and maybe was engaging in wanting the police officers to actually fire at him. The facts indicate that when entering the home, one of the police officers believed that they saw Mr. Case reach for something. They saw a shadow and that he was maybe reaching for his waist, and they believed maybe it was a firearm. And the result of that is that Mr. Case was shot. Now, eventually, after the interaction, they did find, I believe, a firearm within the hamper. And so after all of this, he was convicted of assaulting an officer, and also his firearms were confiscated, and a lot of other things were wrapped into this challenge. Now, in response to this, Mr. Case argued that the officer's warrantless entry into his home violated the Fourth Amendment, so the gun and the other evidence that they found at the residence, that should be suppressed because of that warrantless entry into his home. Those arguments were eventually rejected by the lower court, but eventually his challenge made its way to the Montana Supreme Court. The Montana Supreme Court on review affirmed the denial of his motion to suppress that evidence based on the warrantless entry into his home, but it was a controversial 4-3 split in that decision, and so there were, 3 judges on the Montana Supreme Court that wanted to rule in his favor. In that 4-3 decision of the Montana Supreme Court, they adopted a standard that requires police to have an objectively reasonable belief that there is an emergency before aiding someone without a warrant. This standard is substantially less than showing, probable cause to enter the home, and so that is a big part of this dispute here in this challenge. Mr. Case argues that the police should have to meet a higher standard and potentially also have a warrant to enter the home. He argues that the lower court decision conflicts with other appellate court decisions and Supreme Court precedent on, requiring probable cause to warrantless entry into a home, and when emergency aid can actually be used as a rationale to enter a home without a warrant. Case actually argues that the officers here lacked an exigent circumstance to enter the home without a warrant, and that is also based on the facts that they sat outside his home for 40 plus minutes before they decided to actually enter. He also argued that the search was not justified under the community caretaking doctrine, which was also struck down by the Supreme Court in that 9-0 unanimous decision in Caniglia. Montana, in response, argues that the objectively reasonable basis test amounts to probable cause in practice, and that the split is more semantic than actually substantive. Now, one of the big things in this challenge is Mr. Case and his attorneys cite to the unanimous decision in Caniglia as support for why, this actually was wrong and why the Supreme Court should strike down what the lower court said. They state in the petition that This case gives the court the opportunity to clarify the contours of the exigent circumstances doctrine as applied to emergency aid situations, an issue that has consistently confused and divided the lower courts since Caniglia was decided. They go on to state that the court should take this case to resolve the standard for warrantless home entries under the emergency aid exception. In Caniglia, the court made clear that while community caretaking concerns did not alone justify a warrantless home entry, police could take such action to render emergency assistance if exigent circumstances were present. But because the case provides no occasion to examine the contours of the emergency aid exception, courts remain divided and in need of guidance from the Supreme Court. As the concurring justices in Caniglia noted, the exigent circumstances exception implicates recurring heartland emergency aid situations and important real-world problems, including situations involving suicide risk and elderly incapacitation. Yet the majority here struggled to even identify the correct doctrinal framework for law enforcement to address situations like this one, collapsing the community caretaking doctrine into exigent circumstances. They argue that to clarify that framework and provide the guidance Caniglia invited, this court should grant cert. Mr. Case argues that after Caniglia, many lower courts have been confused on how to apply that standard and instead just apply kind of a de facto exigent circumstances analysis instead of really playing off of Caniglia. Now, if you're not aware of what happened in that Caniglia case, which is very relevant because that's potentially what's going to be expanded upon here on this decision, essentially one night during an argument with his wife, Mr. Caniglia got a handgun out, put it on the dining room table, and asked his wife, "Why don't you just shoot me and put me out of my misery?" Now, after this interaction, the wife decided to leave the home and she stayed at a hotel overnight. The next morning, she tried to call her husband, but she couldn't reach him. And then she thought maybe something had happened to him because he wasn't answering. Because of that, she decided to call police and wanted a welfare check on her husband. And so she met the police officers at their home. Now, soon after the wife and the police met, at the home, they found Mr. Caniglia was actually on the porch. He denied, that anything was wrong. But despite that, and despite all of those statements, Mr. Caniglia was actually taken by ambulance to do a psychiatric evaluation and hold at the hospital. Now, during this interaction with police officers, Mr. Caniglia told the police officers that he did not want them to confiscate his firearms. He didn't want them to take them. The police officers promised that they would not confiscate those firearms. However, once the ambulance actually left the home, the police officers, according to the wife, told her that he wanted the firearms to be taken from his home. So she believed that that was correct. And so they entered the home without a warrant based on all of that and confiscated and seized those firearms. This case eventually made its way to the Supreme Court back in 2021. And on review, the Supreme Court issued a rare 9-0 unanimous decision in favor of Mr. Caniglia. The majority opinion was then written by Justice Thomas. And Thomas stated in that opinion that the Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The very core of this guarantee is the right of a man to retreat into his home and there be free from unreasonable governmental intrusions. And based on that, the Supreme Court unanimously found that the warrantless entry and seizure of firearms was in fact unconstitutional. The Supreme Court has not expanded upon that decision or readdressed Caniglia in the scope of that since 2021. There were a few cases that made their way to the Supreme Court, but the Supreme Court rejected those and did not expand upon those. One of the cases that actually made its way to the Supreme Court was a red flag case, and I believe they rejected that one as well. But now the Supreme Court has decided to step back in on this issue and decide if they're going to expand upon what they said prior in Caniglia. This is important because it impacts everyone's protection against these warrant exceptions and when police officers can use, certain community caretaking or, welfare check, issues or all of these, aid situations or exceptions to enter your home without a warrant. These parties will now submit additional briefs to the Supreme Court, and next term, the court will now hear arguments on this case and rule on this issue. The Supreme Court now has an opportunity to clarify or expand upon that 9-0 unanimous Caniglia case, which can have direct downstream impacts on what protections we all have from police officers entering our homes without a warrant and when can they fall under certain exceptions. This is a case we're going to be watching closely during their next term, and it's going to be interesting to see how these, develop. How do these briefs develop? Potentially, does the federal government and the U.S. government, the Trump administration, step in and also file an amicus brief? So as I get more information as this develops, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.